Good morning, everyone. My name is Stephanie Heron Rice, and I'm an attorney with the Justice Center of Southeast Massachusetts in Brockton. Today, I will be walking you through with Shep Heaton, our AmeriCorps service member in the Justice Center, through the Massachusetts Defense for Eviction System, or MAID. We're going to be talking about what MAID is and why it's so relevant for today's virtual court world. So what is MAID? Massachusetts Defense for Eviction is a self-guided clinic in a box. It replaces the experience of an in-person eviction defense housing clinic, given the COVID-19 state of emergency and the social distancing recommendations. Through MAID, tenants can fill up to 7 different motions, including answer, discovery, request for interpreter, a motion to file late answer, among others. It helps folks even if they're not at the very beginning of their eviction. And we'll see it in action in a minute, but what I mean by it helps people when they're not at the beginning of the eviction is that it helps file late answer and discoveries as well. MAID is designed for pro se tenants, meaning tenants who do not have an attorney, and it is designed to meet a 6th grade reading level. There is no legalese in MAID. It is all plain English. MAID is available in 6 languages, and as you will soon see, you can switch between languages if you are working with a tenant that is of limited English proficiency. The website is also accessible to screen readers and includes a text-to-speech feature. So why is MAID important today? Well, because of the global pandemic. MAID is a tool you can use to safely, remotely, assist tenants with their court pleadings or give tenants the tool to use on their own. MAID turns what could be complicated legal questions into digestible, plain English, fact-based questions that then populate the legal theories that flow from the answers into the court forms. Service is a good example of that. Is the service I got from the landlord defective? That would be a really complicated legal question for a tenant to ask. What does service mean? What does it mean to be served properly? It requires knowledge of the law. Answering that question requires knowledge of the law. MAID breaks it down into: when did you receive your notice to quit? When did you receive your notice to go to court, your summons and complaint? How did you receive it, right? Did you get it by someone handing it to me, mail to you? And then based on what you answer, it either populates a defective service defense to the eviction, or it doesn't, without the tenant or the person completing the interview needing knowledge of the underlying law around or rules rather around service. So providing services during a global pandemic, how do we do what we used to have, face-to-face conversations with a client, providing them guidance and support in the era of COVID-19? That transition is very, very front and center in the MAID system. There are multiple tools built into the interview system that allow for this flow of communication. For example, and we will demonstrate some of these in a minute, but for example, the interview is shareable at any point via what we call a QR link, which is that image that you just point through to with your phone, and it populates in your cell phone. So you just click and you're into the interview. You can also share it with text or a link via text or a link via email. This means that if a tenant is working on an answer and they get stuck, they can easily share where they are in the progress with you, so you can pick up and answer their questions or figure out if they missed anything, etc. Or you could complete the entire interview with the client on the phone and then just share it for them to sign with their finger on their mobile phone or computer. This also allows you to if your organization is in a position to offer services such as printing and filing for folks, this feature makes it so that people can complete their answer, discovery, and other pleadings and share it with you, such that your organization can then print it and file it with the court or mail it with the court. So we recognize that filing the forms with the court and serving them or giving a copy to the landlord will be a barrier for many tenants in these coming months. We have some e-filing tutorials available on Mass Legal Help, and I will point to those at the end of our training. Mailing also is always an option. People can mail physical files to the court or to their landlord. If the landlord has an attorney, because of the COVID-19 state of emergency, that attorney absolutely has to accept documents via email. So if the landlord is represented, the tenant can simply email their answer in discovery to serve the landlord with the papers. If the landlord is not represented, they can certainly agree to receive the paperwork by mail, but they're not required to do so. If the landlord chooses not to accept paperwork by mail, the tenant will have to physically mail them the paperwork to their address, to their physical address. So why file, answer, and discovery? Well, we covered this in our last session. Shep walked us through it, and that recording is available in the same place this one will be. So I'm going to not cover it in a lot of depth, but the main reason is it gives the tenant a chance to tell their version of the events, their side of the story. It includes, an answer includes any and all facts, defenses, and counterclaims, if applicable, laid out to allow the judge to follow the history of the case, to follow the relationship between the parties, and to decide if the tenant met the legal standard for succeeding in that particular defense or claim against the landlord. The answer can also be a vehicle for the tenant to exercise their constitutional right to a jury trial. This is known as a jury demand. And like we discussed last session, the jury demand is due by the answer date and can be included in the answer. We do not advise a tenant waive this fundamental constitutional right without a meaningful conversation with an attorney. So always preserve it if you have not had a discussion with an attorney about what waiving that right means. Discovery is a chance for the tenant to learn more about the landlord's case. Can they really prove the allegations they are bringing in the eviction? What evidence does the landlord have? And finally, time. If a tenant files timely discovery requests, the case will be, in normal times, outside of COVID, continued for 2 weeks. In the era of COVID, filing timely discovery will not affect what we are calling, or what the court is calling rather, the Tier 1 status conference, but timely discovery, at least as we understand it now, will make it such that the Tier 2 trial event is not scheduled less than 2 weeks before Tier 1. So 2 weeks, that's how tenants are getting the 2 weeks right now. Tier 1 will not be continued due to timely filed discovery, but Tier 2 will be scheduled at least 2 weeks after the Tier 1 event with a timely discovery filing. So how long does May take? If it's a client doing it by themselves, it's about 30 to 60 minutes. And if it's one-on-one assistance, then we're talking about 20 to 45 minutes. And the 45 minutes is more for when working with limited English proficiency clients, because translating always takes a little longer. So where do we start with May? How do we get started? What's the best way to do this? First, you gather the client documents. The notice to quit and the summons and complaint are the most important. Shep, do you have your summons and complaint and your notice to quit? You ready to get started with the interview? Awesome.
I do, yes.
Wonderful. So once we have the notice to quit and summons and complaint ready, we get to filling out the forms, which we'll do in a minute. And after you fill out the forms and sign them, you download them and e-file. Again, we will point to where the e-filing tutorial step-by-step is located on Mass Legal Help. You can also find it if you just Google Mass Legal Help Eviction Tyler with a Y. Let's get into it. So I'm going to stop sharing my PowerPoint screen and move on to sharing my made screen. Let me just make sure it's up, because nothing is ever easy. Let's see. Okay, Zoom, cooperate. There we go. So when you get to the Massachusetts Defense for Eviction MAID, this is the page you will land on. I got here. The website is gbls.org/MAID, but you can quickly arrive there by Googling or plugging into your favorite search engine, MAID GBLS eviction. Okay, and so once you land on this page, you go down. Here is frequently asked questions, which is important. There's a lot of information right there. And the last tutorial we did is saved right on that page as well. But if you want to start the interview, you click Start Online Form. This is the disclaimer, just saying you accept the terms of service, and then we begin. Who is completing this interview? What I mean by the system being accessible to many different languages is this. If you click on Portuguese, everything will be translated into Portuguese, but you can click back to English, okay? So I'm going to click, and you can also have the text read out loud if you have a error. If you have a disability around reading, you can just highlight it. And of course, it's not working right now, but I promise it was working this morning. Anytime you have any issues with MAID, you can always complete this survey down here and send feedback to Quentin, the architect of MAID. Okay, so I am an attorney who is completing this interview. And let's get started, Shep. So did you get a notice and complaint yet?
I got a summons and complaint, yeah. No,
Sorry,
I got the notice
and complaint yet?
Yeah, I got the notice and the summons and complaint, which I think is your question.
Okay. Wonderful, yes. So I got the notice of a court case to evict me, summons and complaint. If you had missed your first court date, that would take you to the late answer form we talked about. So you got a notice and complaint. And what is your current address? I'm going to plug in the Justice Center's address, 62 Main Street in Brockton, Massachusetts. And if you plug in your phone number and your email address, you will get alerts from the system. So Shep, is this also the address you're being evicted from?
Yes.
Wonderful. Let's click next. So what is your name?
Shep.
Shep.
Last name Heaton.
Got it. Any suffix?
No.
Okay. Is there another tenant that lives with you, Shep?
No.
No. Okay. Important to note that that MAID accommodates multiple tenants, meaning if there were more people living with Shep in the apartment that they are being evicted from, multiple tenants could file the same answer and each have a place to sign it, such that it applies to all of them. It's filed on behalf of all of them. Okay. So how are you named on the court summons? Does the line to defendants, occupants, and tenants up front say anything other than Shep Heaton?
No.
No. Okay. So if you had clicked yes, that would have populated a defense around failure to name a proper party. Can you we can remind you about important dates. So my recommendation is to not do this right now because of COVID-19. Because of the COVID-19 emergency, the traditional rules of summary process procedure are not in place or suspended right now. And so the deadlines might not coincide with when you're actually having to be in court, and it might get confusing. So what is your landlord's name, Shep?
Laura Camara.
Okay. Laura Camara is one of our colleagues. Hi, Laura. Sorry that you're the landlord again. And what type of landlord do you have? So important to note, in MAID, there are very helpful green, anything that is clicked on that is highlighted green, you can click to get a picture or a sample or more information. These arrows, these question marks here are also really helpful, giving you tips here and there. So if your landlord, how do you know if your landlord is a company, corporation, or LLC? There's this handy tip. It might include LLC in the name. Many landlords, except very small landlords, are companies or agencies. So what type of landlord do you have, Shep? And it's
An
okay
LLC.
if you don't know. An LLC. Okay, wonderful. So that should prompt us to see, does Laura Camara have an attorney? If they don't, that would populate a defense. What does Laura have an attorney, Shep?
Yes.
Yes, they do. And what's the attorney's name?
Head Ehrlich.
Okay. And let's say he lives at 200 Commonwealth Ave. That sounds like in Boston, Massachusetts, 02122. That sounds like a place a landlord would live. For court name, it's very helpful for litigants to see highlighted in the sample summons where that information would be. Because the address we plugged in is in Brockton, the Metro South Housing Court Brockton session automatically populated. Shep, can you double check that's the court that you are that will be hearing your case?
That's correct.
Okay, let's keep on going. So because of the COVID-19, the first notice that tells you to go to court will not include a date. The summons and complaint will not include a date as traditionally they do. It will say something like TBD. You will then get a letter from the court saying the date and time that your tier 1 event will go forward. Shep, have you gotten that letter yet?
I got that letter, yes.
Okay, wonderful. So your answer is due. Ooh, come on now. Your answer will be, and my computer froze. Never a dull moment. So let me just briefly pause the share to try to wake my computer up. There she goes. Okay, thank you. And let's get back to it. So your answer will be due 3 days before your tier 1 event, like we discussed in our last session. So Shep, you did get that letter. And when does it say you have to go to court by?
December 16th.
Okay, so 12,
2020.
16, 2020. Thank you. Okay, so look at your notice to quit. Let's get into the reason for the eviction. Look at the notice to quit. And again, green means that there is a sample here, a sample notice to quit. Can you see that if I zoom in?
Yes.
Okay, wonderful. So, what does your notice to quit say is the reason why you are being evicted? Put the answer that is closest to what you see on your notice to quit. Shep, why does your landlord want you out? What's the reason for the eviction?
They say that I owe rent, or it says non-payment.
Okay, got it. Okay. This is a special page dedicated to COVID-19 defenses. So mainly the CARES Act, the Stimulus Act, and the CDC eviction moratorium, which will be in place until December 31st, 2020. So it walks tenants through it. You may have a defense because of COVID-19. Check any answers that are true below. If you're not sure, answer to the best of your knowledge. So, does your landlord have a federally funded mortgage, or do you live in a federally assisted property that is covered by the CARES Act? In order to find out if that applies to you, you can visit this link and that will take you, can you see that?
I can.
Or do I have to reshare? You can?
I can see it. Yep.
Wonderful. So this will take you to a tool in which you can look up if Freddie or Fannie Mae back up your landlord's mortgage. Okay, so back to our maid interview. Do you think your landlord has a federally funded mortgage?
No.
Okay, let's not select that. And did you send your landlord a CDC eviction moratorium?
Yes.
Declaration.
Sorry. Yeah.
So I believe there should be more information on the CDC eviction moratorium here, connecting this page to the Mass Legal Help page where everything regarding the CDC eviction moratorium lives, all the information. And so I will send feedback about this, and I will do that once we're done. Okay. So you did send him or send Laura a CDC eviction moratorium declaration?
Yes.
You did. Okay. And have you applied for any rental assistance?
Yes.
Wonderful. So, information about you and your family. Do any of these apply to you? Do you live in public housing or have a housing voucher or subsidized rent? English is not my first language. So let's click on English is not my first language because this is a really nice feature of MAID, one of my favorites. You click English is not my first language and it will immediately prompt you to ask if you need an interpreter. Again, we have the different languages up here. So if we wanted to change this into Spanish, el inglés no es mi primer idioma y necesito un intérprete. It will then prompt you to answer in what language. Once you click your language, what happened? Back. You can always go back. So English is not my first language. I need an interpreter. And in what language? Once you select a language, that will populate a request for interpreter form that will be printed out or at least generated along with the rest of your pleadings. Okay. It's again giving me a little bug when I switch over to, let's go back. Like any software, it has bugs and we just have to report them and keep plugging along. Okay, so there we are, we fixed it. So English is not my first language. I need an interpreter in the Cantonese language. Okay. Anything else that applies to you? Are you a survivor of DV, or is anybody in the household over 60 or under 6 or has a disability?
No.
Okay, next. So let's talk about your rental agreement next. When did you move in?
I guess 10 years ago. So
okay,
around November of 2010.
2010. Okay, got it. Do you live in the property as a caretaker, handyman, PCA, and do not pay rent?
No.
Okay, then how much do you pay for rent?
$1,400 a month.
$1,400. And how often is your rent paid? Monthly or weekly?
Monthly.
Okay. Do you know what your rental agreement is? Do you have a lease, or is it a month-to-month, week-to-week tenancy at will? Well, we know it's not week-to-week now. Or do you not have a rental agreement, or you don't know?
I have a lease.
Okay, you have a lease. Wonderful. So now we're moving to your notice to quit. If you remember, that is this document that you said non-payment of rent, right?
Mm-hmm.
So is it a 14-day notice to quit?
Yes.
Okay. All of these are populated because of previous answers, right? So we previously said that the summons and complaint had your name. So I think this is what that populated. And that there's nobody else on the lease or living with you. So this is why this is populated. And the kind of notice to quit, because we previously said that's what the eviction was about. The fact that it's previously selected doesn't mean you can't change it though. If something is not correct and for example, the notice to quit doesn't have your correct address, then you can just easily change that by just clicking, okay? So 14-day notice to quit, does it have your name on it?
It does.
Does it include the name of everyone who signed the lease?
Yes.
And does it have the correct address?
It does.
Wonderful. So Does your lease require a longer notice period?
No.
Okay. So defenses around non-payment of rent. Do you owe the money your landlord says you owe?
Yes.
Okay. And you were behind on your rent when you got the 14-day notice?
Yes.
Okay. Did you ever give the landlord the full amount of money that you owed
No.
or offered to pay the full amount of money?
No.
Okay. Does DTA help pay your rent?
No.
Okay. Let's move on. Information about your apartment and your building. Has your building been foreclosed on?
No.
Has your landlord tried to lock you out?
They haven't.
Have they entered your apartment or home without permission or without advance notice?
Yeah.
They've done that, okay. And that could be a breach of your quiet enjoyment. And so there's no need for SHEP to know that term. There's no need for SHEP to know the legalese behind the claim, just the facts, right? Laura Camara entered my home without permission or without advance notice. That's a fact-specific question that the tenant can answer without having to worry about the broader legal issue. Have they sexually harassed you, or have you paid for one or more utilities? Was it converted
Yes.
recently to a condo? Yes, you paid utilities. Okay.
Yep.
Did you pay a security deposit?
Yes.
Okay. And what about last month's rent?
Yes.
Okay. So since you mentioned you have a lease, let me try this guy again. Nope. So I'll include that in my report. Type of lease. So what was the original lease period when you moved in 10 years ago?
1 year.
Or your latest
believe.
lease that you signed? Okay. And does the lease end and doesn't renew, or does it renew for another term or month to month, or it's okay if you don't know?
I don't know.
Okay. So the timing of notices. It's important that your landlord file the eviction case and pre-eviction notice at the proper time. You may have a defense if this was not done in your case. So peppered in through May, sprinkled through May are really helpful informational videos about the law. This one talks about the summons and complaint and whether you were served properly. So if I play this, you will get this awesome, really straightforward video. Can you hear that?
I just came home and found this summary process summons and complaint under the door. I don't know anything about going to court. What am I going to do?
When you get served a summary process summons and complaint, it means your landlord is taking you to court.
Right. And so that walks you through what it means to be served properly, right? And that is in several places. There's one about discrimination, one about conditions, etc. And so those, I want to point out that those can be really helpful, especially for tenants doing the interview on their own. So Shep, when did you get the notice to quit?
October 20th.
Okay. And when did you get the summons and complaint?
I got it November 7th.
Okay. How did you get it? Do any of these apply? I got the summons and complaint by someone handing it to me, or it was mailed to me or left at my apartment, taped or tacked onto the door, sometimes under the door.
It was left at my apartment.
Left at your apartment only, or was it also mailed?
It was also mailed.
Also mailed. Okay. Find the line on your summons and complaint that begins with because. What does the summons and complaint say is the reason for the eviction? Does it match the notice to quit?
Yes.
Does it include the names of all the adult tenants who signed the lease?
Yes,
And does it have your correct address?
it does.
Okay. All of these would populate defenses, okay? And they are pre-selected based on your previous answers earlier in the interview, okay? So if the summons and complaint doesn't have your correct address, or it doesn't include the names of all household tenants, or it doesn't match the notice to quit, those would all be legal defenses populated in your answer, again, without needing, without the need for you to know the underlying law and just the facts of your case. Okay, here we have another helpful video on bad conditions. And I want to know if these are available in other languages. They are. Malas condiciones. There we go. Al Departamento de Sanidad o inspectores de salud debieron haberle dado un reporte listando los problemas con su apartamento. It walks through best practices when proving your conditions, what bad conditions in an apartment are, what to do about it, etc. And so those are really, really helpful videos throughout the interview. So back to English so I don't confuse you. Work this time. So select any of the conditions you've had in your home in the past 6 years, even if they are fixed now. Do any of these apply? Shep, insects, cockroaches, mice, water leaks, electrical problems, lead paint, leaky windows. Any of those?
Yeah, electrical problems.
Okay.
Defective ceilings.
Defective ceilings.
No heat.
No heat.
And
Anything else?
that is it.
Okay. How did you tell your landlord about the bad conditions you just listed? Did you tell him on the phone or send him something in writing? Did somebody like the Board of Health come and report it, give him a report? Or did the conditions exist when you moved in?
I told the landlord in person.
Okay. And there's a spot for you to fill out other if these don't apply, if you notified him some other way. Did you repair the apartment on your own?
No.
Okay. So retaliation, what does that mean? It means your landlord is evicting you for something you have a right to do. Making a legally protected complaint, for example, about bad conditions is a very common situation. So did you take any of the following actions that you believe are the true reason your landlord is evicting you? Check all that apply. So you told me that you told him orally. So that one doesn't apply. Did you withhold rent because of bad conditions?
No.
No. Did you report the bad conditions orally or in writing to a public agency like the Board of Health?
Yes, but only recently.
You did. Okay, got it. Are you a member of a tenants union, or did you sue your landlord or obtain a protection order under 209A, or a harassment prevention order against your landlord, or reported some sexual assault or stalking, or you are a survivor of domestic violence and the eviction is related to that, or changing your locks or for safety reasons? Do any of these apply?
No.
Okay. And did any of these happen within the last 6 months? So did you report the bad conditions to the public agency within the past 6 months?
Yes.
Yes. Okay. Protected classes and discrimination. Do you have any reason to believe your landlord is discriminating against you? Again, a very helpful video about what constitutes discrimination. And so after you've read all of this, discrimination may include not wanting to rent to children. And if you're a pro se tenant, completing the interview on your own, after you've watched the video, you can answer, do you have a reason to think your landlord is discriminating against you? Yes or no?
No.
Okay. Moving on, paying the money owed. You may have a right to stop the eviction if you paid all of the money you owe to the landlord no later than the answer date, December 13th. That answer date was calculated based on when your Tier 1 event is scheduled. Again, answer now is 3 days before your Tier 1 event, which you answered earlier when it was going to be. So, have you paid the rent you owed your landlord by this date?
No,
No,
not yet.
not yet. Okay. So moving on, waiver creation of new tenancy. If you're, in some cases, actions you or your landlord can take, make the notice to quit invalid or waive it. Look to your notice to quit to answer this question. Did any of the following happen after you received your notice to quit on October 20th, 2020? Again, this is populated by your previous answers. Did you pay rent after October 20th, 2020?
No.
Or sign a new lease? None of the above. Okay, so that doesn't apply. So if you see, that changes the second question, right? Because if you paid rent and your notice to quit had this language, that has legal ramifications. It affects whether or not you have a defense. When you say I did not, that goes away. Some questions about your last month's rent that you previously identified you paid. How much did you pay?
$1,200.
$1,200. And did you pay that to your current landlord?
Yes.
Okay, and have you lived in your apartment longer for a year? We know yes. And did they pay you interest each year on your $1,200 prepaid last month's rent? No, they did not. Okay, so that will populate a defense. Breach of quiet enjoyment happens when your landlord does something or allows something to happen that makes your apartment hard to live in. This is what we previously discussed. So all of the previously answered questions that would give rise to a breach of quiet enjoyment argument are pre-selected for you. You previously said you didn't have heat. You previously said bad conditions were in your apartment and that Laura entered your apartment without permission. Anything else in this list that applies?
No.
Any other way in which your landlord made your apartment or allowed your apartment to become hard to live in?
No.
Okay. You may have claims against your landlord for improper handling of your utilities. This stems from your earlier answer that you did not have heat. So, no, actually this stems from your representation that you've paid for some utilities. So, have you been billed for heat, hot water, electricity, or gas without a written agreement to do so, to pay for it?
No, but I have been billed for utilities that cover other people's apartments.
Okay, great. And have they charged you for water?
No.
Without proper submetering in place. Okay, next. Let's talk about your security deposit. What was the amount of your security deposit?
$1,200.
$1,200. Okay. Did your landlord do any of these? Accepted a deposit for more than 1 month's rent? We know that's not true. Their rent is $1,400. Failed to deposit into the money into a separate bank account, or did not provide receipts, or did not give you interest on every year, the anniversary of your deposit, did not provide you with a statement of conditions, or did not take responsibility for a deposit you paid to a former landlord. Any of these?
None of the middle four. Or like failed to, that one and then the three others. Failed to keep the deposit in a separate, and then failed to provide required receipts.
Those apply, interest. Okay.
Yes.
Interest, okay. Those three?
Yeah.
Okay. And then there's consumer protection law. where you charge illegal fees or an amount of rent that you never agreed to pay or charged court fees unlawfully?
No.
Or do you think there are any unlawful terms in your lease? No. Okay. So, any specific reason why you think the landlord's case should be dismissed?
I
This
don't
is
know.
the chance for the tenant to just plug it in. And if you don't know and you have nothing to say and you've answered properly, then you can just skip it. So this is an important part, a jury trial. This is what we discussed in our last session and what I covered at the beginning. It goes through what is a jury trial and should I keep my jury trial? Again, if you have not consulted with an attorney, our advice is you keep your jury trial. Requesting time to move. So we don't know if you win your case. If it goes to trial, the judge or jury can decide in your favor or in your landlord. If they decide against you, explain why you would need more time to move. And some things to consider are, anybody over the age of 60, does your child have an IEP and attend a local school district, or anything specific about your family composition that would make it such that you need extra time to move. Do you have any young children, or is anybody disabled or over 60 in your household, Shep?
No.
Okay. How about I have been in my apartment for a decade?
Oh.
Time to Okay, almost done. So now it's going to think for a minute because we are moving on to the discovery. Okay, you can ask your landlord up to 30 questions. So something really helpful about MAID is that 26 interrogatories are already selected. So discovery is pre-filled out for you based on your answers in the questionnaire, in the interview. Okay, and so you can certainly go in and change that, but if you don't have time, or if you just want to leave it as is, that's certainly an option, and it can be a time saver. So all of these have been questions relating to the tenancy, repairs. Since you identified that there were some issues with the apartment, repairs are included. There are no disability related questions checked off, since we did not represent that anybody in Shep's household has a disability or subsidized housing. There are questions relating to security deposit, utilities, the landlord's claims, etc. Do you have a federally assisted mortgage? So I'm just going to leave them as is and click next for the interest of time. And then again, for document productions, there was a limit of 30 interrogatories before. This you can ask as many as you'd like, as long as they're related to your case. And again, the pre-selected sections relate back to your previous answers earlier in the interview. And so if we want to just leave it as is, we just click next. And here is where we are able to sign our court forms. So I can either sign on this computer if I was Shep, right? Let's clear this and go back. Or I can share for signature. So Shep, could you open the camera on your smartphone and focus on this picture? Try to take a picture of this. We'll see if it works through the computer. No need to press the shutter, just focus on the image.
It worked. Okay.
Awesome. What do you get?
I got, it took me to a website that says GBLS, took me to the MAID website, and then I have a little page that says add your signature.
Awesome. Can
And
you show me
then-
your screen, or at least
Oh.
try to? I'm not sure if we're going to be able to see it.
Let's see.
Let me.
My
stop it
screen
there
is
for a second.
severely cracked, but
No problem. Yep, there it
Says
is.
add your
Add your
signature.
signature. Wonderful. I'm glad that worked. So that's one way to do it, just by Zoom. Another way to do it is just email a link or text a link. And again, that is very, very user friendly. It pops up, you click on it, and you get your signature block like Shep just did. So actually, Shep, if you, back. So there you go. So if you want to actually go ahead and sign it using this QR code,
yes.
I believe that will send it back to me.
You have a spinny wheel going round and round.
It's
Okay.
thinking.
It says thank you for signing. So
Okay, let's see. Delivery method. So you must give a copy of the forms you are working on to your landlord or their attorney, and they need to get the forms no later than December 13th, 2020. So delivery method. How are you going to give it to your landlord, Shep?
in hand.
Okay, delivered in hand. And when are you going to do that?
December 10th.
Okay, 12/10/2020.
That's
Ooh, 12/10. Geez, 12/10/2020. Next. And here is how you would look up who your legal services provider is and apply for services. Thinking. And that should generate our forms. In the meantime, while I give it a minute to think, I want to share the Tyler videos with you. The videos on how to e-file in your eviction case. Oop, our forms are ready. Let's see. Congratulations, you finished the interview. So there are several options you have, right? For forms to print and file today, you click there, or you can download a copy into your phone. Okay, so here are our forms. Do you see them?
yes.
Okay, go to court December 16th. There's your signature that you signed on your phone through the QR code. Again, this is Laura Camara's her landlord. That's Shep's name, her signature, and a CC to Laura with her attorney's information right there. This is the answer form with all the facts we plugged in. And because you said that you weren't served properly, there it is. Because you said you gave her a CDC declaration, there it is. The retaliation defense we talked about and counterclaim that you reported bad conditions in writing to a public agency, the bad conditions in your home that we talked about, that you told the landlord, the security deposit law violation, last month's rent that we identified, and the quiet enjoyment that we identified as well. Okay.
Mm-hmm.
So that's it. That's made. The next step would be giving a copy of the forms to your landlord or their attorney. Again, if your landlord is represented, the attorney must receive the forms by email. If you choose to do it that way. And if your landlord is not represented, they can certainly agree to receive the forms via email. But if they say no, you'll have to mail them or physically give them in hand, as Shep said she was going to do on December 10th.
Yes.
Okay. So now I want to point out very, very briefly how you learn to e-file your forms. We have this really, really handy step-by-step tutorial that Laura from my office worked on with Mariah. And we are very thankful for it because it's a complicated system. So this lives on Mass Legal Help, which is a great resource for tenants in Massachusetts. It really has a lot of information and it's updated really often. These trainings are going to be saved there, like I said at the beginning. So to get here, you can go to Mass Legal Help and search here. This is the website, masslegalhelp.org/housing/evictions e-file MA. However, the easiest way to really get here is by just plugging into your favorite search engine the words Massachusetts e-file eviction Tyler. Okay. And so that gets you here. And it just gives you a step-by-step process on how to do it. Hi, Laura. We are just walking people through how to file, how to e-file once their forms are all done using the helpful videos you prepared with Mariah. And unfortunately, I have to break it to you. You were also the landlord for today's presentation and you broke into Shep's apartment without her permission. So tisk tisk. So e-filing with Tyler is not intuitive, but these videos really go a long way into showing how to do that. So I'm just going to play it for 1 second just so you get a feel of it and exactly how step by step.
I'm so glad you were able to use the Massachusetts Defense for Eviction interview to prepare your answer and discovery requests.
That's exactly where we
Next
left
steps
off.
are to file your answer and discovery request with the court and to give copies to your landlord.
I heard I can file my answer online. Is that true?
Yes, you can file your answer, discovery requests, and any motions you need to file with the court online. You use the Massachusetts Court e-filing website, e-file.
So it has really clear graphics.
You can use
really clear graphics explaining exactly what you need to click and how and when to get your paperwork into the court, filed with the court online without needing to physically mail or drop off any documents. And in the era of COVID-19, that is certainly important to keep in mind. So I hope that was helpful. That's all we have for you today. Thank you, Shep, for your help. And we'll see you guys soon.